How you doing? I am so excited to be here with you today. You have no idea. I was in Mexico City last year, and I gave a talk about how I got into Bitcoin and how this industry changed my life. And I'm about to talk to you today about some really, I think, interesting work that hopefully will change this industry. I am the CEO of Third Key Solutions, and Third Key Solutions is a key consulting and management company. We do corporate governance. So how many of you work in Bitcoin or have a Bitcoin business? Oh, fantastic. So maybe I would say a quarter of the audience. And how many of you wish you did? Oh, okay, a few more. Excellent. So we help companies who operate in the Bitcoin space, who hold Bitcoin, we help them hold it securely. And we do that using multi-signature and hardware wallets and process controls. Basically, we try to make sure that you get to keep your Bitcoin. We also do estate planning. So what that means is if you hold a ton of Bitcoin or other cryptocurrency, the question is, what happens if something happens to you? Will your heirs actually be able to inherit that Bitcoin? So those are two projects that we work on a lot at Third Key Solutions. But today I'm going to talk to you about DAM, which is the Decentralized Arbitration and Mediation Network. I'm going to talk to you today about why arbitration is important for our industry, and I'm going to teach you how you can implement arbitration today and make your company safer and better. So let's get started. Our industry is facing a pandemic. And yes, I use the word pandemic because that is the level of risk we are at. Right now, as you know, Bitcoin and most blockchain technologies do not require identity in order to do business. The problem with that is you don't know where your customers are. And so they can bring a lawsuit in any jurisdiction throughout the world. And that's a problem. That's a problem for risk analysis, and that's a problem for investment. So, how do we deal with this? Well, the good news is there's a vaccine. We have an opportunity to opt out of traditional court systems. We have an opportunity, if we take it, to decide, no, we're not going to be subject to jurisdiction all around the world. We're going to decide what jurisdiction applies to us. Sounds too good to be true, right? Totally isn't. We get this through arbitration. How many of you have heard of arbitration before? Okay, great. I would say the majority of you have. That's fantastic. So in our industry, I need to do a little clarification. Sometimes we use the word arbitration to mean just a third party who's going to decide the outcome of something. So sometimes you hear, oh, we have an arbitrator on our buy-sell platform. That's not what I'm talking about. What I'm talking about today is formal arbitration by way of international treaty. And so what this is effectively is private dispute resolution. And this has been used for decades by multinational companies. If you have a credit card in your wallet, who's got a credit card or a debit card? Yeah, all of you. Guess what? You're already parties to arbitration agreements because it's part of the terms and conditions in all banking agreements. So you're already doing this, you just don't know it yet. We can bring this to our industry. To show you how powerful this is, the New York Convention has been adopted and ratified by over 150 countries. The ones in blue are the ones who are signatories to this international treaty. Notice Argentina is there. Also, as an aside, Argentina passed a local arbitration law in 2015 dealing with local arbitration. So you'll notice if you do business with someone in any of these countries and you adopt arbitration, that award is enforceable in any of those other countries. Now let me give you a second to digest that because you might be like, okay, why do I care? It's actually even more powerful than a local court award. Let me give you an example. If you and I did business here in Argentina and I did something wrong to you, okay? You took me to court here and a local judge awarded you, said, yes, you're right. You can collect $100,000 against Pamela Morgan. Good luck. But let's say that I had that and let's say that you got an award. How would you enforce it? Well, traditionally, you would have to take that award and you would have to go to a local court in Chicago, Illinois, where I am from, and you would have to try to get a judge to acknowledge and enforce that court award from Buenos Aires. How successful do you think you're going to be? You have to ask, pretty please, judge, would you pretty please enforce this award? Really, I got it fairly. Really, I did. With an arbitration award, guess what you get to say to the judge? By way of international treaty, you must enforce this award. The local court no longer has discretion. So your local award here just got the power of international treaty and got the power of international law simply by way of doing arbitration. More than just enforcement, arbitration gives us the freedom to choose. We get to choose processes, we get to choose laws, we get to choose things that we don't get to choose in local courts. For example, substantive law. What is substantive law? Well, effectively, that is, what is a breach of contract? How do you know if I did you wrong? What is negligence? And each local jurisdiction defines what those are. If we don't decide substantive law in our contracts, that means the substantive law of whatever jurisdiction the lawsuit is brought in applies. For example, I would be subject to breach of contract laws in Buenos Aires, and do I know what those are? I don't, right? And do you know what the breach of contract laws are in Chicago, Illinois? No, you don't. Likely you don't. So, we can designate what substantive laws apply to our agreement simply through contract, and you can do that with or without arbitration. Procedural laws. Procedure governs how many days do you have to respond to someone's complaint. So I file a lawsuit against you. Do you just have forever to respond? No. Courts have rules set up, and those are the procedural rules. On all of our hearings to be held in Chicago, Illinois. And you can do all three of those by way of regular contract outside of arbitration. But here's where things get interesting. In arbitration, you can choose who your judge will be. You can't do that in local court. In the United States, how your judge is decided is by a lottery. And many times that judge has no knowledge of the underlying subject matter. But with arbitration, we get to choose who our judges are. We get to choose how many judges will decide the case. We can say 1, we can say 3, you can say 7 if you want. It'll get costly, but you can do that if you decide that that's what you want. You can also decide what language the hearing will be in, which is something that you don't get the joy of doing if you go to local court, because all of those hearings will be held in the local language, and too bad for you if you don't speak it. We can decide the duration. How long is this thing going to last? I'm sure you've heard of cases in the US, and I think it's probably similar here, where cases go on for sometimes decades. Why? Well, appeal after extension after extension. With arbitration, we can say no. We can say the award is decided within 6 months of the start of the hearing, and we can do that by way of contract, and it's fully enforceable. We can decide what evidence is going to be presented. We can decide that we're going to do as most of the rest of the world does, and have a hearing based solely upon documents, and not bring witness after witness after witness and fly them across the globe back and forth. Hearings can also be confidential, and they can be private. We can require a written decision that shows the reasoning. How did you judge? How did you come up with this decision? How did you decide that I won, or how did you decide that this person won? With arbitration, we can require the judges to write out their reasoning, and that matters, not only for appealability, but it also matters for your future conduct, so that you can understand how to continue to operate. We can decide what appeals process applies, and if we don't like the decision, we can decide all of those same procedural issues relating to appeals. And most importantly, as I talked about before, we have enforcement. We have the enforcement of international law. Ultimately, we have the freedom to choose. So why don't people do this? Well, one, because people don't know about it. There's also a problem in our industry where people say, you know what, this is technology. We float above jurisdiction. Maybe some of you remember the famous language, the now famous language of the Tao that says, the code is law, the code is everything, and no legal jurisdiction applies to us. And the problem with that is that it is as effective as a sugar pill. It will not actually protect you from a local person filing a lawsuit against you anywhere in the world. So how do you actually get protection? Well, if you don't have some sort of protection, the law will step in for you. The law is never shy to do that. How many of you use Google Docs Anyone in here? Okay, great. And did you know if you open a Google Doc and you just start typing, what's the font? The font is Arial 11, right? That's true. You can even try it right now if you want. So the font is Arial 11, but let's say you're like a Comic Sans kind of person, or maybe you want, a 24-point font. You can change it, and that's the same with the law in many instances. In many cases between commercial parties, you can change what the default law is, but the problem is you have to take affirmative action to do it. You have to put it in writing, you have to do it. So if you don't do it, you'll end up with a default law, which isn't probably what you actually want. So other people in the industry say, you know what? We float above jurisdiction, and I'm not going to do business. I'm going to quarantine myself. I'm not going to do business with anyone who isn't full security, completely anonymous, party to party, dark net, whatever. And the problem with that is that you significantly limit your freedom. Now you can only transact with this small number of people. Wouldn't it be better to actually be able to transact with people all around the world? I say yes. So how do we do this? How do we actually start using arbitration today? It's pretty simple. First of all, arbitration clauses must be in writing, so we have to put it in writing. What does that mean? That means for those of you that are doing business today, operating software, put it in your terms and conditions. For those of you that are starting companies, we just heard from a bunch of startups here. Those of you that are starting companies, you all have founder agreements, right? Oh, I see some furtive looks. You're looking away. So you should be having founder agreements that dictate the terms between you and your co-founders. And those should include arbitration clauses so that if things go badly, you don't end up in local court. Now, some of you are thinking, that's not going to happen to me. Let me ask you a question. Do you remember the first person you kissed? Think about it. Do you remember the first person you were in love with? How many of you are still with that person? Okay, we've got one. Okay? Well done, congratulations. But you see that even the best laid plans, even love doesn't last. And so what you want to do, if you're starting a company in this industry, please, 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 do a founder agreement. Now is the time to have the difficult conversations. Now is the time to decide how you're going to deal with disputes when they arise later, and they will inevitably arise. So you want to do that in writing. Any contractor agreement. So for those of you that are developers or coding, if you've got an independent contractor agreement, put an arbitration clause in there so that you can dictate the terms of how this is going to play out. So most contracts, you should have an arbitration clause. So how do you do it? Do you have to hire a lawyer? You're like, oh, I hope not. You don't have to. It's a great idea to have a local lawyer make sure and look at your clauses that you build. But the American Arbitration Association has a free clause builder that you can build international arbitration contracts. And it walks you through step by step and says, how many judges do you want? What law do you want to apply? And it goes step by step, and it will actually create a whole clause for you that you can then drag and drop into any of your agreements. So you could, in theory, go on your phones right now and start building your clause and maybe even have it in your terms and conditions before I'm done talking. You're like, oh, you're not going to talk that long, are you? There's coffee to be had. So I want you to know that arbitration is not 100%. Nothing is 100% secure. But this is good in 90% of the situations that you're going to encounter. Arbitration will not work for criminal. So you cannot put in your contract that any criminal sanctions will go to arbitration. Obviously, the sovereign is not going to allow us to bind them in that way. But for commercial contracts and contracts with local customers, you can very easily put the arbitration clause in, and it should be effective. There's a couple of really great side effects to doing this. And one of them is innovation. So as a lawyer, one of the things that I love about this space is innovation. I love changing the way that systems work now, rebalancing power and seeing what's going to happen with this trust revolution. And one of the things that we can do if we include arbitration is we can start offering other alternative dispute resolution services on top of arbitration. In the commercial world today, typically that's seen as mediation and then arbitration. And for those of you that don't know, mediation is when you bring a third party in and they sit down and talk with both people, or both organizations, and they try to help those organizations create a solution for themselves. So unlike a judge, the third party doesn't come in and dictate what you will do, but they try to get you to understand what your underlying needs are and how your needs can be met as well as the other person's. But we don't have to just do mediation. We could do things like crowd jury. You just heard about that, right? Arbitration can bring commercial viability to things like crowd jury. Because the problem with crowd jury as it sits right now is that it's unenforceable. If both parties agree that they're going to go to crowd jury, and crowd jury makes a decision, and one party isn't happy, what do? They go to local court, and they say, hey, we have this crowd jury thing, or maybe they don't even mention it. But that's not binding. And so you can't make the local court recognize a crowd jury outcome. But guess what? With arbitration and with contract, we could. So this provides the incentive and commercial viability to start actually innovating in the legal space, which is, I think, is something we desperately need. Ultimately, this is about the freedom to choose. I've written an article about this issue, and this is an issue that's near and dear to my heart. Right now, our justice system requires identity. The only way that you can go to local court and get justice, if you can get it there, is by identifying yourself. Why is that? Why? Does it have to be that way? Now that we're working in systems where identity is optional, can we uncouple identity and justice? Can we say that no longer justice requires a postal code that's in the right place, a skin color that's the right color, gender that's correct, age that's correct? What happens if we actually are able to create real blind justice? How does that change our society? What does that do for us as community? So I think that when we start investigating and incorporating arbitration, right now, arbitration requires identity. But as we start to develop these innovations and we start to work in this space where we're no longer requiring national identity, we can then develop alternatives and innovate in this area. So that brings me to the DAM project. The DAM project is the Decentralized Arbitration and Mediation Network. And we wrote a paper on this about, 6 months ago before the Dow crashed. And we talked about what it might look like to first bring arbitration to our industry and then to start innovating with smart contracts and start creating systems where we can incorporate dispute resolution into smart contract systems, because we know inevitably disputes will arise. And so the question isn't, will we have a problem later? It's, will we be able to effectively deal with that problem later? And do we understand what the risks and costs involved will be? I encourage you to take a look at the DAM project. We are looking for arbitrators and mediators around the world, so if you have those skills or want to have those skills, feel free to have a chat with me after. And I wrote an article. This QR code will give you basically everything I just said in a maybe more eloquent way. It also has a table of all of those things that I talked about with choices that you can make in an arbitration clause, and the links to the AAA arbitration clause builder. So I encourage you to take a look at that. This is my passion project, and I really want to thank you for your time and attention.
Wow, wow, wow. You might win the contest. You might win the contest.
Well, we'll see.
Bueno, guys, we are really short of time, yes? I will allow just one question, quick question, yes, there at the back. Shout it. And keep it short.
Great question. So for those of you that didn't hear, the question is, multinational companies and large corporations have been using arbitration as a way to actually game the system in their favor. And so they've been using it against individual consumers and being a what we call repeat player. What I mean by that is, for example, and I'm just using this randomly, I should make up something, right? Google Bank City thing. That's the name of the company. And they are going to continue to arbitrate all of their disagreements by using one organization and a handful of arbitrators, right? And so these arbitrators, because they're paid by this organization, tend to favor the organization that's paying them. So my response to that would be, number one, I don't aim to solve that problem alone. The DAM network is intended to be open to everyone. And so what I would like to do is create a scenario by which arbitrators and mediators can work individually, and they can be asked by organizations and individuals, so that we don't have the repeat player problem. So that when we have someone who is appointed by an organization, we actually have a legitimate conflict of interest review, and we can ensure that that person has not been hired repeatedly by the same organization and coming up with the same answers. I also think that while confidentiality is a benefit in some of these systems, we can also, for those of us who are really interested in transparency, we can start offering non-confidential and public awards, where you can say, I as a company arbitrate, here are all the decisions, here are all of the issues, and so we can use the transparency side of this industry to bolster your reputation. And I would really like to see us go in that direction, but you're absolutely right. Thank you for the question.
Okay. Bueno, we thanks
Thank you.
Pamela. You will find her outside. Very enthusiastic.
Thank you.
Thank you.